After discussing the factors that distinguish a legal system from another, we will now see some factors that lead legal systems toward each other. We will begin with the natural or unconcerted similarity. What do we mean by that? By that we mean when two legal systems end up having similar laws without any consultation between each other, without any will of imitating other systems, but just because of natural reasons they end up having similar laws. Here we can mention the theory of natural laws or natural right, which might lead two human communities to adopt the same laws. For instance, how homicide is considered illegal in all societies, regardless of the modes of punishment. How incest, for instance, is also considered as illegal. Another factor is military conquest, colonization mandates. When a country controls another country and ends up forcing its own legal system upon that conquered country. Yet you must know that this does not happen all the time. At the contrary, we can take two examples. During the Roman Empire, Rome that controlled the whole Mediterranean basin. During the Roman era, Roman law was applied only on Roman citizens. That means the citizens of Rome and by extension Italy, while subjects of the Roman Empire, whether in Palestine or in Lebanon, Phoenicia, or other parts of the Mediterranean, kept applying their own customs and their own laws. For instance, the Jews in Palestine during Jesus' time were applying their own laws. So the Romans did not force their law on non-Romans until 212, when the Emperor Caracalla took a decision to grant every subject of the Roman Empire the Roman citizenship, and then Roman law became applied to every subject of the Roman Empire. And before, subjects of the Roman Empire that were not Romans, these people who lived in conquered territories, kept applying their own customs known as the jus gentium, the law of nations. The same with Islam. When Muslims conquered the Middle East, they did not force Islamic law on non-Muslims. Christians and Jews kept applying their own customs. For instance, Lebanese Christians or Oriental Christians in general kept applying what we call the Syro-Roman book, meaning Roman laws. Also, during colonization, it is not true that every power forced its own system on the colonized countries. For instance, Egypt, which were under British mandate, did not opt for the common law system, but for the Romano-Germanic system. Egypt has a civil code, highly influential in the Arabic world, and every other aspect of its system is closer to Romano-Germanic system than common law systems. Another factor of similarity is imitation. A country or a system might imitate another country's legal system in whole or partly. Imitation is a general law identified by Gabriel Tad as general behavior law. You can find imitation in every field of knowledge. When it comes to law, many systems did imitate others because in general, here the foreign rule will impose itself by the force of reason. In the previous factor, when we spoke about conquest, the foreign rule imposed itself by force of authority. Here it's imposing itself by the force of reason. Why? Because a certain law or a certain legal institution might have a certain prestige. And this prestige, of course, comes from its superiority, its good technique, the fact that it's a successful law. So other countries will be tempted in imitating this law. For instance, the French Civil Code was imposed by Napoleon upon territories in Italy or Germany he conquered. So this is an example of conquest. Yet the French Civil Code influenced lots of other countries that were never conquered by Napoleon. Why? Because of the intrinsic value of the French Civil Code. The same with the German Civil Code, which influenced countries that were never under German influence. So a successful economic legislation will be imitated by others. In Lebanon, we can give the example of offshore companies. In French law, we can give the example of the patrimoine d'affectation. You might remember that from your property law courses. The Egyptian Civil Code itself influenced heavily codes of Libya, of Jordani, and other Arabic nations. A particular factor that leads to imitation is education, the teaching of law. When the legal thinkers and the lawyers of one country are educated in the universities of another country, or according to the methodology and to the curriculum and the law of another country, these legal thinkers and these lawyers are going to get back to their country and try to implement what they have learned into their own legal system, directly or indirectly, which will lead in both cases to imitation. They will imitate the law of the country in which they were educated. In Lebanon, we can give the example of the first French law school that was opened in Beirut by professors from Lyon, which played a pivotal role in the reception of French law in Lebanon. A final way or final factor of similarity is when it happens by concerted efforts. What do we mean by that? We mean that when a group of nations agree together to unify their laws, whether by multilateral or bilateral conventions. We will get back to that later on in this unit. Now I will end this first topic by the very important notion of reception or transplants, or again transfers. In comparative law, this expression is very, very important. Reception, transplants, transfers, réception, greffe, tam in Arabic. What does it mean? Now, there's a historical meaning of the word reception. The word reception was used historically in a certain context. It meant how some European nations, mostly Germany, who did not initially belong to the Roman law tradition, received Justinian code of civil law. And they received the Roman law in the 15th century, around the 15th century, even though Roman law was never a big source of their own law before that century. Why? Because of teaching. Most of German scholars were taught in Bologna in Italy, and it's in the University of Bologna, reputed for Roman legal studies, but also for the technicity of Roman law, which was better than the local customs of the many parts of Germany. But right now, when we speak about reception or about transplants, greffe, what we mean is the transfer or borrowing of a legal rule or legal institution by one system from another. In other terms, it means introducing in one legal system an element from another legal system which proved to be successful. It is rarely the reception of a whole system or the transplant of a whole system, but one or more set of rules or one institution of a system. This falls under the factor of imitation we just talked about. We can give an example, the Torres real estate system. As you may know, the real estate system followed in Lebanon is not the same as the real estate system in France, even though Lebanon was under French mandate, and even though these laws were promulgated while we were under French mandate. The Torrens real estate system, to simplify, is the system we actually have in Lebanon. Publicité foncière, سجل العقاري, the real estate register and its effects on real rights, حقوق العينية, les droits réels. So this system was transplanted into the Lebanese system. And of course, it led to many changes accordingly, because the Lebanese law had to adapt itself to this new institution. Now, many authors denied that real reception can happen, especially, for example, Pierre Legrand, a French comparatist, who worked mostly on translation. He said we can never really translate one legal notion from one system to another, and therefore real reception can never happen. Others said that in religious systems specifically, reception can never happen, because a religious legal system thinks of itself as perfect, as complete, and does not need to receive or have any transplants from any other legal system. However, receptions and transplants do happen all the time. One thing that you must note is that when a certain country, the receiving country, receives a transplant, this receiving nation is never passive. So it's not just accepting this transplant. No, it will lead to changing the received institution itself and changing the institution of the receiving country as well. This leads to the creation of mixed legal systems. To some people, comparative law could be only the study of transplants. We shall see this again in Unit 2. Now, reception can be the transplant of an isolated rule, or a code, or a part of a code, or a constitution, or some constitutional provisions. For instance, in South America, even though the base of the legal system is Romano-Germanic, they transplanted the model of the United States Supreme Court when it comes to constitutional control. We can also speak of a transplant of a legal method, such as classification or structure, or transplant of a principle, such as estoppel. Lebanese jurisprudence have received this phenomenon or this principle of estoppel from the common law. When the receiving country receives the transplant, it might lead to a legal change in this receiving nation. That's why we speak of the theory of legal change, a legal change operated by a transplant from another legal system. And if we transplant one element from system A into system B will change according to this transplant. So it means a general change caused by a particular transplant. Finally, you have to note the word acculturation, which is a lighter version of reception. This happens when two legal systems have been so long and have had a very long-term relationship and very long-term contact between their institutions, that these institutions start to change toward similarity and become more and more similar to each other.